All right. Good morning, everybody. I'm Joel East. I am the Education Chair for MSPS. Welcome to the third Lunch and Learn of 2026. Um, Before we get started, I just want to start out with a few housekeeping things. Um, Please make sure if your name is, like an abbreviation or your full name isn't shown in the chat. Um, if you could just put it in the, or if you could put it in the chat so that Kisty can get your CEUs to you. That'd be great. Um, there's still one more Lunch and Learn left for this year. That's going to be in November, so watch your emails for that. We have the boot camp coming up in September. Registration is out for that, so if you have any texts or anybody you want to send to that, get in touch with the central office. And also, please make sure that you're muted throughout the presentation. So our presentation today is called Lines in the Sand by Rick Linnell. Rick is a graduate of the University of Michigan and Wayne State Law School. He's been an attorney in private practice since 98 and involved in real estate since 96. He focuses his experience in commercial and residential real estate as well as corporate law. He's also been actively involved in commercial and residential real estate development, including acquisitions, development, complex financing, syndications, and workouts. Rick is the owner of Linnell and Associates PLLC and a multi-year Michigan super lawyer recipient for the real estate area of practice. Super lawyers is a distinction given to no more than 5% of lawyers in Michigan, and his law firm has become one of Michigan's most trusted law firms specializing in real estate law. So with that, I'll hand it over to you, Rick, and thanks for being here.
Thank you. Good morning, everyone. Um, Before I get going, I'm happy to take questions during the presentation, which, unless Joel tells me differently or Kisty tells me differently, I would just suggest you unmute and ask. So with that said, thank you for the introduction. It is myself. I have 9 other attorneys that work for me, 8 of which only handle real estate and corporate work. Most of the corporate work is tied to commercial real estate. Everyone litigates. The lone standout attorney handles probate and estate planning. For today's class, I believe I might have more material than I can get to, so I'm going to try and distill it down as best I can, or at least focus on what I think is most valuable. I'm looking for how to get this to, Oh, there it goes. Perfect. Okay, let me skip this page since we already did it. So there are 3 legal theories in Michigan by which somebody can gain the property of another. And by the way, I'm assuming my shared screen is showing.
Yes, it is, Rick. You're
Perfect.
good.
Okay. There are 3 theories in the state of Michigan by which you can gain an interest in someone else's property. Adverse possession is the one that is generally best known. This is where somebody occupies the property of another. I could occupy Joel's property. He could occupy mine. We don't live next door to each other. I don't even know where Joel lives or anyone else here. There are elements to adverse possession. These are things that must be established. All of them, not most of them, not more than 50%, not a preponderance of them. All of these elements must be established to prevail. First, actual possession. There must be physical use of the land you intend to claim if you are claiming to be the adverse possessor. It must be open and notorious, which means visible. So people say, well, what does that mean, Rick? And I'd say, well, in the most extreme example, you have built your house, barn, yard for your commercial real estate on the property of another. That would be open and obvious, open and notorious. What is an example where it isn't? Your septic field is on the neighbors. Your underground irrigation, your underground drainage pipes, even though it is occupying the land of someone else, that, generally speaking, would not satisfy the open and notorious requirement. And again, if you fail in any element, You lose your claim. It must be exclusive. It cannot be shared with anyone else. So if you are using the property of someone else, but they are also using that property, you will not be able to establish the exclusivity element. Continuous, uninterrupted for the entire statutory period, which we will get to what that period of time is, but it must be uninterrupted and continuous. Now, the law does distinguish, for instance, a dock, a seasonal dock. If a dock is put out every season from the last day of May and taken out on the first week of September, which would be the typical season for having a dock in, that will be considered continuous by a court. Now, there could be other factors that change it, but as a general rule, that would be continuous even though it's not year-round. Why? Because seasonal docks are not in the water year-round. Hostile, under claim of right. This means you are doing it without the owner's permission. Any permission given by an owner will defeat an adverse possession claim. Even if it's begrudgingly. Hey, neighbor, you are a jerk. You did whatever you did, and it's on my property, but I'm going to let you do it for the time being. That defeats a claim. And I want to be clear about this. The defeating the claim with permission is if the claim has not been fulfilled. In other words, if you've met all the requirements, which will go to the time period next, 15 years, if you've met every requirement and 15 years has passed, the fact that permission is given afterwards does not negate the adverse possession. Why? Because you've met all the requirements and now you have gained that property by adverse possession. So the neighbor saying, well, I guess you can use it, Rick. I mean, you've been doing it for 15 and a half years. There is no permission. They could say those words, but that does not amount to permission. Why? Because the adverse possessor has already obtained ownership of the land. Tacking is allowed. Tacking is the ability to step into the shoes of the predecessor owner. So the current owner can use the prior owner, their grantor's ownership to get to the 15 years. In other words, I bought the property 2 years ago, and I have, as part of that, I have a shed, and my shed is on the neighbor's property. Well, I've only owned the property for 2 years, so I can't meet the 15 years unless I wait another 13 years to get to a total of 15. But if the person I bought it from also had the shed there and maintained it and used it exclusively as their shed, and they were there for 10 years, well, now I'm up to 12, but I've got to get to 15. If the grantor to my grantor had the shed, used it exclusively, and they owned the property for 4 years and did it the total of 4 years, so now I'm at 16 years, I am able to use the prior grantor's possession of the adverse, or at least the claimed property that I'm trying to get via adverse possession. They can use the prior owners to get and meet the 15 years. The standard of proof, clear and cogent, that is much greater than preponderance of the evidence. Preponderance of the evidence is 51%. Clear and cogent, there isn't a percentage that you would attribute to it, but it must be clear to a court. In other words, if you can't make a clear argument that the court says, aha, yep, I see where it was exclusive. Aha, I see where it was hostile. I see where it was continued. If you can't make those arguments to a clear and cogent standard, you lose. So an adverse possession claim could be lost without the other side defending. Now, that would be dangerous and unusual, but the point is there is a burden on the party making the claim, asserting that adverse possession claim. And if they don't meet those requirements, they fail, even if there's no defense. We do not have a property tax requirement, so you don't have to be paying property taxes on it. You have to meet the other standards, but that's not one of them. Cannot make a claim of adverse possession against any municipal or government-owned land, so state or local municipality. Also, as a general rule, you are unable to make a claim against a property that you have an interest in. Now, that may sound odd and it may sound obvious. Odd meaning, why would you be an adverse possessor against yourself, Rick, if you own property that you're on and you're making it, or you're forget that, you're making a claim to property that you already own? Why are you even doing that? I don't understand. What I'm specifically referring to is where a property owner owns some portion of land and it abuts a common element of a condominium or a site condominium, or land that's for the benefit of all co-owners in a plat. And again, this is residential or commercial. In that particular instance, the adverse element, so open and hostile, that becomes the real focal point even if you can meet the other elements. And the reason is because the courts say to themselves, well, wait a minute, you were using this, we'll call it a park lot on a lake. You live next door and you were using this park lot and you put a dock on the park lot for yourself. Not an unusual case. I think, have 3 of them right now and have had many in the past. And the argument is, well, yeah, but I put that dock there and I'm the only one that used it. So that was adverse. It was open, hostile, etc. If you're on the other side, you would say, and the court might say, but you had a right to use the park lot. It's riparian park lot, and you put a dock there, and I can accept that maybe you weren't allowed to put a dock, but how are the other co-owners supposed to know that your use was adverse? Because for instance, you had a right to be there, and maybe you overused that a little bit, but you had the right to be there. And adverse possession, to meet the standards, you're supposed to be using it at a level that anyone who has an interest in the property would know for a fact that you are doing it adversely. Now, there is an exception to this rule. There's been a few cases about it. So I think of one that comes to mind on, I believe it was Mesa Day Lake. The neighbor to the park had built a boathouse, a substantial boathouse, partly about 4 feet onto the park lot. And the argument was made, hey, the neighbor is part of the plat. The neighbor gets to use the park lot, so it's not adverse. And the court found that that level of use, putting your boathouse partly on the park lot, was sufficient to demonstrate adverse use. In other words, anyone who saw that the neighbor's boathouse was on the park lot wouldn't say to themselves, well, I don't know if they're really, excluding me from using that portion of the property. I don't know if that's really adverse. The court found, yes, that met the element of open and hostile and notorious and all the elements, in fact, and that person was, in fact, awarded a portion of the park lot, which brings up another point. Typically, the portion of property that's being occupied is the only portion of property that will be obtained via adverse possession. So, in other words, if you are occupying 4 feet of a 50-foot wide park lot, you don't get the park lot, you get the 4 feet. There can be sub arguments about, well, wait, if my structure is 4 feet into this property I'm adversely possessing, I'm also going around the exterior of the building for maintenance. So I really am adversely possessing, let's say, 6 feet, 2 feet to use to maintain the exterior of the building, and then 4 feet that contains the building itself. I wrote down the Springfield Township case. So we have a case where we are vacating and abandoning a paper road, so a road that was never built. And the neighbors, and I'll see if I can give you let me change my shared screen. Let's see. I might need a little help on how to change my shared screen.
Yeah, there should be, Rick, there should be.
Share this one and go back and share the screen he's on.
Yeah. let me see here. Next to your name on the participant list, there's a stop share. I don't know if you see that or not.
I see the stop. Oh, maybe it's this easy. Let's see. Ah, okay. I think I got it. Okay. This is a GIS aerial of the property in question. Where my cursor is, I believe everyone can see my cursor. This is the subject property, just a residential home. The paper road is to the north. The parcels just north of this, also residential in nature, have made a claim. So we are trying to get rid of this paper road. My client wants that paper road to be part of his property so he can use it. The neighbors to the north have claimed that they've been using this paper road, that they've been dumping landscape refuse in this paper road. And one claims that they've got a shed that's partially located in this paper road and that they have become adverse possessors of the road. The problem for the people to the north is they are, well, I shouldn't say the problem. One of the things that I want to address is they're not in the same plat. So this line right here is the plat line. And so it could be adversely possessed. We don't have that issue where I raise, well, wait a minute, you have a shared interest in the property you're seeking, even as a co-owner, and you have, of course, have your own property. Here, the people to the north do not have an interest in the plat to the south. However, this road was deeded in favor of the road commission until about 3 months ago. And as a result, no adverse possession claim could accrue while the road commission had the ownership, or at least the interest, the dedicated interest in this paper road, which is an example of where you can't be an adverse possessor against the government. Here, they could be against a plat because they don't have any interest in this particular plat, but they are not even remotely close to the 15 years. So now let me go back to my... Okay, so let's go to the next slide. Acquiescence. Acquiescence is the second theory in the state of Michigan by which you can gain property over another. It's a boundary line doctrine. Unlike adverse possession, where I said I could adversely or attempt to adversely possess Joel's property and he could do the same to me, even though we don't live anywhere near each other, as far as I know at least. Acquiescence is where two abutting property owners make a mutual mistake as to where the common boundary line is. This is not nearly as well known as adverse possession, but this is actually the legal theory that more often than not is the theory that's relied upon when somebody gains an interest or ownership in someone else's land. Acquiescence, there are three types of acquiescence. Generally, you only run into the first type, which is that parties make a mutual mistake and treat some area as the common boundary line, even though it is not the common boundary line, and they do so for a period of 15 years. The other kind is where there's a dispute between neighbors and they agree to some location. It's the wrong location. And then the last is an intent to deed to a certain location or a certain amount of property, but for whatever reason, the description does not follow what was intended. With the first kind, and again, by far the most common kind of acquiescence, generally speaking, the parties never discuss, at least in detail, where the common property line is. In other words, they don't sit down and I say, hey, Joel, we live next door to each other. I'm going to put a fence up and I'm putting my foot right here. This is where I think the common property line. And Joel says, yeah, I think that's it. Rick, I tend to think that's the right area, and put your fence up. I'm not saying it doesn't happen, but generally what happens is someone puts a fence up or some other line of demarcation. It does not have to be a fence. And the neighbor sees the fence go up and doesn't necessarily think it's anywhere but on the common property line, even though it's not discussed, not agreed to, not in writing, but treats that demarcation as the boundary line. So they mow to their side, I mow to my side. After 15 years, that becomes the property line. Now, you need to go to court to have it recognized, and I should have said this about adverse possession. Adverse possession is to make a successful claim, you must meet all the elements. Meeting all the elements does not mean you've gone to court. Adverse possession does not require you to go to court. However, if two neighbors are in a dispute and I say, well, I've adversely possessed your property, Joel, and Joel says, no, you haven't. Well, I can say I have, and maybe I have, but that's all I've got is what I say. Maybe what my attorney told me, maybe what I got from AI, maybe what I read on Google. I don't know, but all I have is what I say. Well, if I want to sell that property and I tell the buyer, yeah, I own this area, this rectangle, but I also own this portion of the neighbor's property. If I'm the buyer, I say, well, okay, how do I know you know that or that you own that? And I say, well, because I'm telling you, I met all the elements. So people go to court to have the court recognize it. But I wanted to draw that distinction. The court recognizing an adverse possession claim doesn't mean that you're not the owner when you meet the elements, because you are. But you want it recognized at the court. You want a court order. You want a survey. You want to record that survey. You want to do the split and combination. You want to do all those things to formalize it. But again, if you've met the elements and the 15 years has passed, you are an owner. Same with acquiescence. You become the owner after 15 years, but you still want it recognized in court. I already said it's the 15-year period. The standard of proof is preponderance of the evidence, which is effectively 51%. So it is much easier than the standard of adverse possession, which is a clear and cogent standard. No hostility is required, which is potentially a key advantage. Now, I've noticed in my slide, I've used the word permission twice, once in the third bullet point, once in the last bullet point. So I want to draw the distinction here. Permission, it does not defeat a claim. I think that the way I wrote this is not clear enough. If you're a neighbor and you go to the other neighbor and the other neighbor says, yeah, I've got no problem with the fence being here. I have no problem with that. That's what I was getting at. That does not mean that the person has actually given you permission, which I will touch on at the bottom bullet point. In fact, I'll do it now to draw the distinction. And a neighbor confirming that they think a certain area is the property line, even though it isn't, is the type of permission I'm mentioning in bullet point 3. The last bullet point is if I am an owner and I now find out where the actual property line is. So I know it to a fact, I got a survey. And I then say, but look, we've been neighbors for 14 years, 11 months, and 22 days. And I'm not interested in getting into it with you, Joel. You've been a great guy this whole time. I tell you what, I give you permission to use that portion of my land that's on your side of the fence. If that happens, that permission does negate an acquiescence claim. Why does it negate an acquiescence claim? Well, because I am no longer making a mutual mistake, because I got a survey that tells me exactly where the common property line is located. And therefore, the 15 years of mutual mistake did not occur. Tacking is permitted. So again, I can, even if I've lived in my house for 2 years, I can use prior ownership's occupancy of the area or the mistake, which generally is the way it is. Once a fence goes in, assuming it's not challenged right out of the gate, oftentimes it will be there for years, decades, unless somebody has a reason to get a survey. Evidence that typically is used to show a common boundary line that's other than the actual property line. Fence is the most common one. The fence does not have to run the entirety of one side of a property line, and there's no set standard. Hey, you got to have 80% of it fenced or 90% fenced or 75% fenced. That doesn't exist. But as the fence section becomes less and less, 10% of the common property line, it becomes much, much harder to establish in court that both owners treated a fence that only ran 10% of the common property line as establishing the entire 100% of common property line. Hedges can be used, driveways. I'll come back to mow lines in a second. Retaining walls, seawalls, maintenance patterns. But I would tell you, maintenance patterns has to be more than mowing. There has to be something else. Oftentimes on a hedge, someone will say, well, I maintain my side of the hedge, they maintain their side of the hedge, and that's the pattern of maintenance that someone alleges. With mow lines, simply mowing your neighbor's property is insufficient to establish any claim. I haven't even got to the third one yet, which is prescriptive easement, but it is not possible to establish a claim just on mowing. Why? Because everybody would be suing everybody. I live in a regular neighborhood, an old platted neighborhood, and when my children go out and mow the lawn, I want it to look nice, so they mow it in rows. And when they go to the neighbor's property, they make a 180-degree turn on the neighbor's property and then come back and mow another length of our property. And the neighbor does the same exact thing. When they mow their property, they come on our property. So if someone said, well, wait a minute, I've been mowing this 180 and that's about 32 inches, and I now own that, there would be courts filled with this stuff. In addition, in my example, it's not exclusive because both people are using it to turn on. They're using my property, a portion of it. I'm using a portion of theirs, which means there's an overlap. So mowing is insufficient. Now, there is a case, I believe it was on Pine Lake in Bloomfield Hills, Michigan, where a mow line, there's an argument that a mow line was grounds for acquiescence claim, a successful acquiescence claim. And I've had that raised in cases I've been involved in. And I believe Paul Harvey is the one, and now it's time for the rest of the story. And that is that it's true in that case, a mow line and an argument that one party had been mowing this particular line all along, it's true. It definitely said that, and that party did prevail. However, there was a pole, I don't know the nature of the pole, but a pole that was at the seawall and stood some 4 or 5 feet higher, I believe, than the top of the seawall. That was the guidepost for mowing. And at the front of the road, this was in a cul-de-sac, so the lots kind of pied out as they went towards the water from the road, that the two driveways in the front almost touched each other in the right of way. They were that close because they had very small frontage. And the court reasoned, well, the area where the two driveways almost touch each other, that was one point, and the pole at the seawall was the other point, and that was what was used for the mow line. And the other side did concede that, yes, they had been mowing that line. What I would suggest is that it was not the mow line that allowed the party to prevail on their acquiescence claim. It was the fact that you had two fixed places that had been there for more than 15 years, of which both parties agreed set the mow line, if you will. So it wasn't mowing by itself. It was more than that. And mow lines just by themselves are going to be insufficient. A successful acquiescence claim results in the common boundary line being moved. So the way this is written is maybe not as clear as it should be, but there is a split and combination. The prevailing party gains that portion of their property on that side of the mistaken common boundary line. Next, prescriptive easement. This is the last theory of the three in Michigan. It's the right to use another's land without owning it, and it's acquired through long-term use and without permission. So again, if permission is given, it defeats a claim of prescriptive easement. A prescriptive easement is identical to adverse possession with the exception of exclusivity. Every other element is identical. The standard of proof, clear and cogent, identical. Everything is identical, but it does not have to be exclusive, which is really the distinction. So a scenario may be where I've had some cases recently. I'm thinking about one where somebody was accessing their property driving over another person's property. They weren't landlocked. They had their own separate access, vehicular ingress, egress, but they would occasionally drive over a portion of my client's property to get to their own property. And they claimed a prescriptive easement. They understood that my client also used the property, so they couldn't meet the exclusivity, but they claimed to be able to meet the other elements. They were not able to. But if you can meet the other elements, a prescriptive easement claim can, in fact, be established. And unlike a deed that you would receive in an acquiescence or adverse possession claim if you're successful, a written easement would be recorded in the chain of title. Oftentimes, it is actually the court order is certified and then recorded in the chain of title. And again, the easement is what's recorded. There is no actual change in ownership. I made a little table that talks about the three theories and sort of the pros and cons, or maybe not pros and cons, but the differences between the two. I don't think I need to review that unless somebody has particular questions. I will move on to, let's see. I'm going to move on. Before I go to the cases, I'm going to go to my next slide. So surveyor considerations for boundary disputes. I'm not here to tell surveyors how to do their business, because I'm not a surveyor. But I think maybe touching on some of the things that we run into might be helpful for a surveyor to know in advance, and to consider when they are talking to a client who is calling them out for a boundary dispute, or maybe a boundary issue arises based on what the survey reveals. Boundary disputes, in my experience, typically result in the surveyor going back more than one time. I don't know how the survey business works, but I can tell you, as a small businessman myself, I like to be able to get into a project and do it. And when someone says, "Well, can you make this little change?" and I'll be happy to do it, but it's not as profitable, and sometimes can be frustration, like you're getting picked at. Not that you shouldn't charge your services, I do, but it's I prefer to, if I can, if I understand the situation, to say, well, I know you're only asking for A and B, but I think you're going to need C and D, and here's why, based on what you've told me. And that might cut down on frequent visits. The survey for a boundary dispute, in my mind, you are definitely going to need to depict all improvements that are within at least 5 feet of the common boundary line. And obviously it could be more if the encroachment is greater than 5 feet. I want all fences shown that are within the 5 feet. Any trees, including the trunk or flares, which are the above ground roots. Why are the above ground roots important? Because determining what is ownership of a tree includes the trunk and any flares, which means if you're claiming the tree is yours and it's on your neighbor's property, then those flares would also go to the extent of property that you are claiming, or by acquiescence, or maybe not a prescriptive easement. Bushes. I know this might seem trivial, but the base of the bushes, as well as the canopy of the bushes, any walkways, concrete, stone, mulch walkways, any improved, or paths that have just been created by just sheerly walking on it. There's no actual improvement, but it's been walked on. any drainage, any stormwater drainage, any swales, if they have not natural swales, I'm talking about man-made swales, any irrigation, sprinkler heads, anything else. Those are the things that are going to become, generally speaking, important in demonstrating a claim or defeating a claim of one of these three theories. Oftentimes, the surveyor will also be requested to be an expert witness. And I would encourage surveyors who want to be an expert witness to do it. I don't think I think it's actually pretty good work. You get paid well, you get paid for prep time, you get paid for, if you get deposed, you get paid for testifying, you get paid for travel, not unlike what you get for a surveyor, although I would think for expert testimony, maybe not the prep, but for expert testimony, that you might charge even more for your hour of time as it's more valuable, but also obviously charging for any preparation. More often than not, we see these cases going to trial unless people settle. But what I used to see when I was younger is I would find that many of these cases would settle by, or not settle, but would be resolved by a motion to the court. It says, hey, the other side can't meet the elements and here's why, and they're defeated. Or I can meet all the elements and here's why, and so I should win now. Don't make me go through the rest of the steps of court, including trial. That seems to be happening much less frequently in my experience. So I think surveyors being expert witnesses, at least in my experience, is becoming the norm on boundary dispute cases. Next, these are possible solutions that can be employed to either prevent a matter from going to court or at least prevent a matter from going to trial. Litigation is expensive and timely. It might very well be the only way to resolve it, but there are other ways, if the parties can come to an agreement, to resolve it. And I would say from left to right, on the left side is a resolution that's most favorable to the encumbered party, the servient party, the one that the claim is being made against. And as we move, I'm sorry, I misspoke. The party on the left is the solution that is least desirable to the party asserting the claim. As we move to the right is the most desirable outcome for the party asserting the claim. On the left, we have a license. A license is an agreement to use. A license is the same thing you get when you go to a Lions game or a concert. It's the license is to sit in that seat for that period of time to enjoy that show or whatever, or sporting event under the conditions of the venue. And if you violate those conditions, you can be removed. Effectively, you can be removed at the discretion of the license holder or the licensor. It's personal in nature. It does not, as a general rule, get recorded. The servient owner has termination rights, so the party against who the claim is made. The dominant party has less rights than under other options. And a license, I put may require a legal description drawing. I think it's important to always have a legal description in writing to know what you are looking at. What's the area that you get to occupy? So the license could be, I get to walk on your property. It doesn't have to be exclusive, but I get to walk on your property to get to the back of my property or to the water's edge, or I get to store my boat during the off season by parking it 3 feet onto your property. A license is, generally speaking, revocable. Oftentimes it's revoked when the party who has the benefit moves or sells the home, or the license could be for a driveway that's encroaching, and the license could say that the servient property, the person who the driveway is located on their property, has the right to terminate upon sale. But also, if the driveway is rebuilt, it must be rebuilt solely on the neighbor's property. In other words, the license terminates and the driveway is now conforming and it ends up on that person's property for whom it benefits. An easement. This is sort of the middle ground. Easements typically run with the land. So that means that's right, which is not ownership, but this easement right runs the land. So if I have that right today, when I sell tomorrow, my buyer has that right. It oftentimes, and again, it depends on what we're talking about, there's a right to terminate it by the servient owner, the burdened owner, if replacement is necessary. So if we're going to have to rebuild the fence, I would want, if I'm the servient property, that fence gets rebuilt on the common property line. But until it needs to be rebuilt, even if it's just being repaired, it can stay there. Issues sometimes come up about taxes because the owner says, well, wait a minute, I'm paying these taxes, but I don't get to use it. And that could be negotiated in an easement agreement. There's also the issue of exclusive versus non-exclusive. Exclusive means the person who benefits is the sole user, which feels a lot like ownership. Non-exclusive means the person making the claim gets to use it in addition to the actual owner. As you might imagine, the party asserting the claim wants exclusivity. The party fighting the claim wants it to be non-exclusive. And that depends on what the parties can come to, or how the parties can come to an agreement. An easement should always contain a legal description and sketch of the easement area that will be an exhibit to the recorded easement to prevent issues going forward. On the far right, a deed. The party making the claim, this is the ultimate solution. This is what you want. It doesn't mean you'll get, because either you can't prevail potentially, or there's risk of prevailing. There's also cost. This will, of course, result in a parcel split, and the question becomes who pays that cost. It could also result in a non-conforming lot, which means this could be even more unpleasant for the party who is the servient one, the one giving up portion of their land. A non-conforming lot can present issues with setbacks in the future. If a home is destroyed and it's rebuilt, or you want to build an addition, etc. So that's something to be considered by the serving owner. Also, any existing lender will have to sign a partial discharge of mortgage. And depending on the scenario, a lender may say, I'll do that, but I want a partial principal payment. Well, the serving owner says, wait a minute. I didn't even like this to begin with, but I thought I might lose, and I thought this was easier, and I'm not giving up quite as much land as my neighbor claimed. But now you're telling me I got to write a check against my mortgage to make this happen? So that someone might find that to be very distasteful. But again, that is a way of resolving it outside of going to trial. Someone might say, well, I'd rather go to trial. Trial can be very expensive, and the results can't be guaranteed. Any attorney that knows what they're doing will not guarantee results. Now, that doesn't mean you might not say, look, you have a dominant position, or this is a coin toss. This depends on how the judge is going to view this fact or set of facts. So a good attorney should be able to give some real input to their client as to how they value the claim. But any attorney that says it's 100% winner hasn't been doing it long enough. Okay, I'm up for questions, but I'm going to move to cases, even if people have questions. But I'm not seeing any questions.
Hey, Rick, it looks like you got, if you go to the chat, it looks like there's a question.
Oh, sorry, I wasn't monitoring that. So let's go to the chat. Is your full name, if your full name isn't included in the participants list, oh, that's not for me. Does allowing a neighbor permission to occupy one's property in order to prevent adverse possession open one up to legal action if the neighbor is injured on your property? Good question. First of all, if you're going to give permission, giving verbal permission defeats the claim, but you could have a proofs issue. In other words, you go to court and you're like, yeah, I told Joel he could use it. And Joel's like, no, he never told me that ever. So if you're giving your neighbor permission, I would send an email that constitutes written permission. You could do it in a text because it doesn't have to be in writing. You could do it in a letter, but I would want something that I could bring to court if I was ever challenged, which generally means you're not going to end up in court, but I'd want something in writing. And preferably, I'd want to send my neighbor an email and say, hey, please confirm that I've given you permission. And generally, if you're in that sort of friendly sort of situation, the neighbor will. As far as liability goes, allowing someone to use property on your side, and we can change the facts, and it might change my answer, but if we have a fence and you're using my side of the fence, or you're using my property on your side of the fence, you effectively have dominion and control over that, which means I do not. And therefore, as a general rule, I have no liability, even though I own the land. I can't say if somebody got hurt that you might not get sued on your homeowner's policy, but I believe that any claim from a neighbor doing that, using your property, even if you gave them permission, they have exclusive control over it. That claim to me does not have merit. And if there's follow up to that, let me know. Let's see. Is that okay? I think that was the only question.
I think you got just one more, Rick,
okay.
from Kevin.
What might an average cost of a claim going to trial? Well, I mean, unfortunately, I have to give you a lawyer answer, which is I don't know, because I don't know how hard the other side's going to fight back. I don't know who the judge is, although I can figure that out when I file. Even if I know the judge, are they having a good day or a bad day? Who's the attorney on the other side? Are they going to be impossible, or are they going to be reasonable? But I'll still give you an answer. But there's huge variables. To me, to go through trial, all in, you are spending at least 20 grand, maybe 25. That excludes the surveyor. You could spend 40. Why is this not sharing? Give me a second here. Oh, okay, it is sharing. Sorry, I didn't realize that. Okay, this area right here. Hopefully everyone can see. I don't know if you can see the red. I don't know if I should get a little, I should try and blow this up a little bit.
You can see it, Rick.
Okay, so this is my client's property. This is a park lot next door to the what I'll call the north and east. You can see several boats that are in storage. It is for this lot is for the benefit of all co-owners that don't live on a lake. My client doesn't happen to have rights in this lot, although it's not really relevant because they have riparian property of their own. An issue arose because, and I don't know if this comes through, but there's a dock configuration, even though the dock is not out, that is superimposed into this aerial on the GIS website for Genesee County. Is the dock visible?
Yes, it is.
Okay, so the dispute was that, and the way this dock is superimposed is not exactly the right location. It's actually tilted with the fixed point being on the land, but tilted south towards my clients. I would say by maybe just a few feet more south. And what was happening was boats were leaving this interior dock section. These are slips, these fingers right here, they're boats here. So when the boats would come out, they would go around their own dock and they would come across my client's riparian area. Riparian surveys are, I think, becoming, quite honestly, a bigger thing. In fact, I was talking to Joel a little bit because I know he does a significant amount of riparian surveys. It appears to me as values go up, lakefront property is going up faster in value. It also appears to me that people are utilizing their lakefront property even to a greater extent than previous. They're having more water toys, so a pontoon boat, a wakeboarding boat, 2 jet skis, a raft, a rack in the water for stand-up paddleboard and kayaks, etc. And that means that the riparian land is becoming even a greater thing. And in this particular instance, that was the issue. The issue was that the neighbor to the north, by virtue of the structure that they put in the water, was forcing boat traffic onto my client's riparian area. So they didn't put anything on my client's riparian area. So it's a little bit different than what you normally see, where someone says, well, you're trespassing. You're putting your dock on my riparian area or your raft on my riparian area. Here, no improvement was placed on my client's riparian area. However, this dock forced traffic onto my client's riparian area. My client happens to be grandparents, so their young grandchildren would come over and swim, but it became very scary for them because boats would come in, sometimes coming relatively fast. They would not hug the existing dock because they don't want to hit the dock. They don't want to damage their boat, which is understandable in general, except that meant that they went even farther into my client's riparian area. We filed a lawsuit for trespass. And someone might say, but what's trespassing, Rick? The argument is that the neighbor, they can use their riparian property any way they want, unless it's against the law. But they can't use it to the extent that it then burdens, in this case, my client's property by forcing the boat traffic. Now, as we got closer to trial, the other side agreed to revise their dock layout. And we came up with a dock layout that has the main dock section running parallel to my client's riparian property line, and all the boats on the north side of that. So it set up a natural buffer, which served my clients' concerns about traffic being routed through their area, but it also allowed the people to the north to retain the boats that they had. And I have let's see, I have a survey. This is see if I can move this up a little bit. This is the actual exhibit that was used in the settlement agreement. So this is my client's house. This is their riparian area. And you can see the new dock configuration that has the main dock section here that almost acts as a buffer, if you will. There happens to be a riparian buffer area. So their dock is not set tight to my client's riparian area. But this is an example of something being settled. Let's go to, okay. And Joel, if you could let me know if there's questions, I'll be happy to go to them. Otherwise, I'm going to keep moving forward with cases.
Yeah, there is one question, Rick.
Okay. Let me see if I can find that. Or unless you.
Yeah, it says, how far beyond the water's edge is a riparian area? That's the question.
Great question. So this is, let's see, this is not showing. Let me change screens. I was going to bring up a riparian survey. Okay, this is a riparian survey. And I'll use this page right here. So this is a riparian survey, and it projects out to the middle of the lake. And I'm going to scroll through because there might be a better, this picture is a little bit better because it's aerial, although there might be too much going on. So generally speaking, a riparian survey is based on fair and equitable use of the water for anybody that has riparian rights. So you own the part of the existing shoreline. It is more advanced than that, as anyone on this call who does riparian surveys or has looked at them, it's way more complicated than what I just said. But I'm giving my sort of lawyer's version of it. Your riparian interests are different than your bottomland ownership, or at least there's sort of a break in the level of use, maybe is a better way to say. So your riparian area is the area from your shoreline to navigable water. And I say that because when you get to navigable water, you could still own the bottomlands. Absolutely, you could still own the bottomlands. But you cannot use the bottomlands in any way that would impede the trust, the Michigan Trust. Oh, I'm trying to blanking on what it's called. It's called the Michigan Trust, but there's another word I'm missing. Anyways, it's the ability of any person in the state of Michigan to use the surface water. If you can get on the lake, you can use the surface water, whether you have riparian rights, live in the township or the city or the county or anything. You get on the public trust. That's what I was looking for.
Hey, Rick,
Yes.
I've got a question. How are canals treated? Are canals kind of the same
Well,
thing?
that's a good question. So riparian rights are the rights that are inherently owned by some or inherent in the ownership of owning property that abuts a natural body of water. A canal is generally man-made. And so canal rights generally emanate from the deed or the plat itself. Now, if your question is in the with respect to the public trust doctrine, anyone can go into the canal so long as they don't interfere with uh, co-owners' use of it. In other words, so if they use a canal and you can't get your boat out or you can't get back from being out on the lake, that level of use is not permitted by anyone, not a co-owner, not anyone using under the public trust doctrine. But if you're saying, well, I don't live on the canal, but I went down there and I wanted to fish, or I'm just poking around looking, and I'm on my stand-up paddleboard or kayak or canoe or boat, you're allowed to do that. So let's go back for a second, though, to navigable water.
Hey, Rick, real quick too. I just wanted to give you the 5 minute warning
Yes,
quick.
perfect.
So
Okay.
thanks.
So the navigable water is generally, although I've yet to see it defined, but generally speaking, it is at 4 feet because most boats can operate within 4 feet. I realize on some of the really big lakes or the big lakes that are connected to Great Lakes, the draft might be significantly greater or might need significantly more than 4 feet. But that to me is generally where navigable water starts. So within that area, defined by your shoreline and to 4 feet or so in depth. Then on the sides, which I'll come back to with this riparian survey, that would form your what I would call your riparian area where you can dock boats, you could put up a raft, you could put up buoys and delineate a swim area, etc. The the riparian survey again, you find the center of the lake and you draw lines from the center of the lake to where the side property lines of a property project out to the water's edge. And then you draw those lines, hopefully at a 90-degree angle, although that I think that's rare, but you draw them out to the center of the lake. So if you can see on this drawing, you can see the lot lines, which are probably a little hard to see, but run almost perpendicular to shoreline. However, the riparian lines project at an angle to the left. It happens to be west. This is oriented north, but they take a western skew, if you will. If I move down, here's a blow up of that same area. Most people put their docks perpendicular to the shoreline. Generally, if you put your dock perpendicular to the shoreline in the middle, which is the recommendation of Eagle, although it's generally not an ordinance requirement, you will be within your riparian area. I'll scroll down. Here's an even bigger blow up of it. And I believe there's a drawing at the bottom that shows the, I guess that this person, it's not contained within this. So the riparian, to me, the riparian lines can be a little bit not common sense because common sense generally doesn't let the average person figure out where the middle of the lake is. From a surveying standpoint, of course, the surveyor might have a little more attention to it. But you can also, I would want to be clear, in a boundary or in a riparian area, you can obtain adverse possession. If you put your dock on someone else's bottomlands for 15 years, or you moor your boat, or you put your boat hoist or something else, you can obtain ownership over someone else's rights and by acquiescence, which is probably the more common theory, like I said earlier, that goes for upland and bottomlands. Let me see if I can get to a few more cases, if you will. Let's see. Okay, so let me change the share. Okay, so this is a survey for a boundary dispute. This is what I would call maybe a more vanilla claim, although I might call it actually a tenuous claim. represented the party against whom the claim was made, which is this property. This is their survey from their surveyor. The argument was, and I don't know how visible it is, so I'll call it out. This property line, so at the top is where the road is, all the way to the bottom is 494 feet. And of that 494 feet, and to the left is the common property line. The person asserting the claim. The person asserting the claim tried to assert that they owned 8 feet into our client's property, running the entire depth of their property. And they made this claim based on a pine tree right here that was effectively straddling the property line, which makes it mutual property. They claimed it was theirs and they maintained it. And these are acreage parcels, as you can probably tell. They also said that there was a pole for a satellite dish that had been abandoned for almost 20 years. And then there was a fence that was about 18 inches. The butt end of a fence was about 18 inches onto the client's property, our client's property. And then there was a pile of debris that they put that was on our client's property and also theirs. And their argument was that if you string together the pine tree, the satellite dish, the butt end of the fence, and the debris, that was a common property line that was abided by and recognized by both parties. Both parties thought that was a common property line. This was sort of a ridiculous claim for various reasons. One, the markers they were using didn't even mark or were contained in less than half of the common property line. In my opinion, you need something much more substantial, 70, 80% of the common property line, where you can point to something and say, this is what we respected. Second, the pine tree was straddling the common property line. The cable satellite was 2 feet onto the property line. The fence post was 0.2 feet onto the property line. And the pile was 13 feet on the property line. In other words, you have this jagged mix, if you will, as it cuts back and forth. And that's just not how property lines are unless they're part of a survey. But nobody imagines a property line that sort of goes back and forth, zigzags along part of their property. And then to make their position even more tenuous, they argued that they used these 4 guides to create a mow line that was 8 feet into our client's property, which there was nothing that they were using that was 8 feet in. Which is, of course, different than the case I mentioned earlier on Pine Lake, where there was actually a pole at the water's edge and where the 2 driveways met, and they used those exact guides and consistently mowed using those exact guides. Here they said, well, we were 6 feet off the pole, we were 7 foot 9 inches from the butt end of the fence, we weren't as far in as the pile, etc. This claim also involved tacking, and it came to light that the prior owner, who was deceased, had a mortgage survey. Now, I realize a mortgage survey doesn't have any value in court in demonstrating acquiescence or adverse possession or even a prescriptive easement. However, that mortgage survey depicted the cable or the satellite dish and the butt end of the fence, and it depicted it in different locations. And so our argument was that mortgage survey, we're not using it for the value as a survey. We're showing that the prior owner who had this mortgage survey, it was wrong, but it was not wrong the same way as the current claimant is making. In other words, that mortgage survey would have led you to believe that the common property line was in a different location than where these current owners are claiming it would be, which means they can't use the mutual mistake of the prior owner. Why? Even though there was a mistake, it was a different mistake. It wasn't a mutual mistake. And of course, our client said there was never a mistake. I think I'm at the end, so I don't want to keep going, but I hope that this was at least provided some information. I am available anytime any surveyor wants to talk. They have a question. If I charge people, that's how I make a living, like you guys and gals do. However, nobody gets charged unless they sign an agreement. So if you haven't signed anything and you're talking to me, I am not charging you. It's interesting to me. I learn a lot from surveyors on these cases, and I'm happy to discuss anything you run across. And just to be clear, I don't charge anybody unless you sign something. And a surveyor asking me a question or a series of questions or explain a situation, I've never charged for, ever. So I'd be happy to talk about anything you run across. Thank you.
All right, thanks a lot, Rick. Appreciate you doing this.
Happy to.
All right, thanks everybody. If your name isn't in the chat, please do it, and Kisty will work on getting the certificates out. So thanks everybody.
Oh, I'm happy to stick around if you keep this Zoom open. I'm happy to answer
Oh.
questions if people have questions now.
Yeah, we can do that, Rick.
Okay.
Uh, All right, it's really up to you how long you want to hang on here. If anybody has any questions, yeah, feel free to put them in the chat or just unmute yourself.
I just saw a question, so let's see. Would the defense of an adverse possession claim cost about the same as the claimant side? Generally, the answer is no. The reason is the burden is on the party asserting the adverse possession claim. As to how much cheaper, it could be as little as half. It could be, as much as 75%. So it's not cheap, as a general rule. I will say most cases get settled. Even though I said they settle or go to trial, the vast majority of the time they don't go to trial, which is just like most litigation. Why? Because of cost and risk. And getting certainty, even if it's not the certainty you were hoping for, if it's close enough, something you can tolerate, most people opt for the settlement versus the actual trial. Thanks, Kevin.